Testing, testing.
I'm just waiting to see if it catches up, guy.
Okay, looks like we're caught up. I have to use this OBS. They changed the format Google did. So it's kind of weird to do it in this way, but we're going to go this way. All right. Travelers, let's just jump right into page 10 of the document. Page 10, FIG disagrees, stating the lack of clarity surrounding the terms labor and services does not permit the insurer to seek clarity outside the pleadings. This is the entire document. I'm going to give it to you. But let's jump, so I'm at page 10. Okay. So this was released just a couple days ago. And this is the case number if you guys want to find it. There is, let me see if I can put this on the page so you guys can pop it open yourself. Well, that's not right. You can comment here. Let's see. All right. So there's the link right here that will get you what I'm going to read or go over real quickly. A couple of things. First off, this is just setting the groundwork of how the case went back and forth, starting with the collapse. Not until we get up to item 4 do we start moving, item number 4, we start moving forward with this document. Joint motion, they were arguing about whether the insurance companies arguing that they should not be insured because they should be able to walk because FIG operated outside the insurance guidelines, and the exclusions right here is what the insurance company was arguing that. Approval provisions of failure or prepare, approved, or provide any map, shop drawings, opinion, report, survey. See, exclusions defines professional services as any service requiring specialized skill or training, including shop drawings. I find that interesting that FIG, that the insurance company argued, travelers argued that FIG could not do shop drawings. And it's more here too. I think that's just, too far of a reach. But here we go. I mean, who can do the shop drawings then? All right. Well, they have reasons why they argue it. They argue that that would put them in a position of the contractor at that point, and they just wanted the engineering insurance. They were trying to not pay. So here's number 4, right here. Finally, in the event the court finds a right to reimbursement, FIG asked the court to limit reimbursement, so they wanted to be reimbursed. The insurance company wants to be reimbursed. It's like a bond. So they asked for the money back mostly, but FIG says to limit the reimbursement to $270,343.52, the amount plaintiffs incurred defending FIG against their underlying complaints. Okay, and there applies the duty to defend. Plaintiff state FIG has elected to largely ignore the binding case law cited in plaintiff's motion. And FIG then argues back, wait a minute, there is no binding case law. It's no such thing. Their lawyer is doing pretty damn good if you read this document. So let's just jump down to what the court goes on to analysis. Duty to defend. The court first addresses whether it can consider the agreement between FIG and MCM as part of its duty to defend analysis. The court next sets the application's legal framework, which guides its consideration to determine whether plaintiffs owed FIG a duty to defend. Finally, the court considers the allegations against FIG and the underlying complaints, followed by additional arguments raised in the parties' briefing. So this is what the court's going to look at for a second. Let me look at my notes here. Analysis. All right, so judge wants these companies to survive. Just remember that. The judge doesn't want to put any of the companies out of business. That's not part of their statement unless we see it in this 31-page document. But let's go ahead and glean through this. I'm going to show you, they're just going over some case law. I only made it up to about page 12, and I decided to go live with you guys. So live, you're going to see me just scan through it. they're going back and forth with semantics, about labor and services, etc. Basically trying not to insure, and one wants them to insure. Obviously, FIG wants them to insure, and Travelers does not. Apparently, and I use the word, I take liberty, obviously the judge wants it to be insured so they can pay out to the tune of all those millions via the insurance company. Remember, this is the judge's, we're looking at the judge's analysis at this point. And when I say judge, it's probably the law clerk. Plaintiffs are not asking the court to acknowledge the existence of the agreement, the existence of which is irrelevant in determining plaintiff's duty to defend. The plaintiff's duty to defend, this is liberty. Instead, plaintiff asked the court to use the agreement to defend the scope of FIG's actions in addition to and in place of the allegations of the underlying complaints. This court will not do. This the court will not do. Even if the agreement provides clarity as to the facts, only the allegations and underlying complaints are relevant to the court's resolution of the duty to defend. The court thus considers only the underlying complaints and the language of the exclusions. So let's see how the court handled the exclusions. Oh, they're going to call it ambiguous. Oh, yes. Let me write that down. Ambiguous. When things are ambiguous, it goes against you. When you're ambiguous, it goes against you. So if they're going to, that's their way. The judge, apparently, that's the judge's way of making the, and I didn't read it yet, so you're hearing me jump in my mind, if you will. That's the judge's way of making sure that whatever the argument you're making, well, it's ambiguous. And since it's ambiguous, well, it doesn't count, basically. Is that it goes against you for being ambiguous. Some would argue that you're ambiguous on that one statement, whatever it may be, that the court's claiming ambiguous, that is actually contrary to what your intent is at that point. So not only is it ambiguous, works against you, but it appears to count in a contrary fashion. So we want to get paid every week. We want to get paid on the 30th. Okay, we want to get paid on the 30th. Well, there's in 1 year there's 12 30s, right? Or 11 30s. March 29th. February. So we want to get paid on the 30th. So we don't pay you February for sure because you said the 30th. So yeah. So now you don't get paid until March, because you said it the 30th. So it's kind of weird. So the ambiguousness can work against you. See the way that works kind of weird like? So there we go. And let's go on. Yes. Are construed against the insurer and in favor of coverage. Yep, there it is. I stopped right there on that word there. Although ambiguous provisions are construed in favor of coverage, to allow for such construction, the provision must actually be ambiguous, because they tend to limit to avoid liability. Exclusionary clauses are construed more strictly than coverage clauses. And then there's the case law. But where a policy provision is clear and unambiguous, it should be enforced according to the terms, whether it is basic policy provisions or exclusionary provisions. And there's the case law again. The term arising out of is broader in term and meaning than the term caused by. Ooh, look at this. They're saying these two are ambiguous. So let's play with these words. It's the way it really happened, guys. It's the way the bridge is really being resolved now. There's this issue. Arising out of the actions. Let's go that. Arising out of the action is broader than the term caused by. I agree that it's very ambiguous to use the term arising out of. Caused by is clearly pointing the finger. So whoever used the term arising out of is obviously ambiguous in their wording, which means it counts against them. Caused by is pretty damn clear. It means originating from, having its origin in, growing out of, flowing from, incident to, or having a connection with. Well, they took away the ambiguity of it when they just gave this meaning to it. Internal quotation marks and citations omitted. The term requires more than a mere coincidence. I'm not going to do all the quotes, close quotes, open quotes on you guys, so just, I'm taking liberty. The term requires more than a mere coincidence between the conduct and the injury. It requires some casual connection or relationship. Alteration added. Internal quotation marks and citations omitted. Wow, they're doing the same thing. Okay. It does not require proximate cause. Well, that would be interesting. So this is very detailed, so you would have to look up this one to see what they mean exactly by proximate cause. Not just Google it, but this specific citation. Okay. Even in exclusionary context, arising out of retains its broad interpretation. Wow, they hit everything. The Florida Supreme Court has held the phrase arising out of is broader than the phrase because of. All right, so you have a Florida Supreme Court, and this is being taking place in Florida. So they've obviously addressed arising out of and because of, and contemplates a more attenuated link. Attenuated. Oops.
Attenuated.
Learn to pronounce.
Attenuated.
Having been reduced in force, effect, or value, it appears likely that the courts will be given an attenuated role in the enforcement of their decision. So using that definition, because of, and it contemplates a more attenuated link. Having been reduced. See, federal courts having consistently applied this broader construction to arising out of. Wow, this is amazing. The mental tongue language here, right? The verbal tongue language going back and forth. So a clerk, I dated a law clerk once, and it was interesting. She would stay up all night on this stuff like this. She would sit there and be part of the case, obviously. Judge going back and forth would hand down notes to the clerk periodically. And at home, she would be up all night, and sometimes I would help her with the research because she'd have to find all this, help her with the connections. That she'd have to put together a document for the next court date. It might have been the next day, literally the next day. So, and that's why sometimes the courts ask for more time or give more time to allow time for the clerk to do the work. The judge goes over it, obviously, or most of the time, or sometime. Goes over top of it, reviews it, and then adds or edits what they feel like they should or need to. But often the clerk is the one that's they tell you they're not leaning one direction or another. The clerks tell you that, or at least she did. But she had a bias in that she would always say there's some percentage of fault on both sides. She would always say that. It was never 100% someone else's fault. There was always a percentage of fault on the other person. And I found that to be biased because, I mean, how is that so? How is it always a percentage of someone else's fault? I understood her statement behind that, that you had some contributing factors. But hell, if you were doing the speed limit, how are you a contributing factor, for example? All right, federal courts have consistently, and it's just interesting. So we're looking at the judge's decision, but a clerk had their hands all over this. When professional services are undefined, Florida courts consider many factors. So we're talking about this again, the professional services, that the judge is trying to disqualify, and I'm saying the judge, is trying to disqualify the defense or the plaintiff's argument, and this is the Liberty Mutual, I believe it's Liberty Mutual, right? trying to whatever the insurance company is, trying to disqualify their argument, their defense that they should not do it because FIG stepped out of line and went into these professional services, which were defined in the contract, which they should not have done. So therefore, that made them unliable, the insurance company, because they operated out of, they flew an airplane. We don't insure airplanes. We insure the guy's car. We didn't insure him working on the bridge as such. We insured his other engineering. So this is but the judge, to make the insurance company stay in the lawsuit, is disqualifying one after another. You're just going to see disqualifying statements against the plaintiff. Hey guys, whoever's here. So this is what the court and I have the link there. So let's read on. So the judge is using, and obviously the clerk is using all these ways to prove it. He even went into Pittsburgh, Pennsylvania to prove it. And there's a Florida, SD.Florida. I'm not going to chase down all this stuff. Whether an act results from the nature of a professional service is determined by focusing upon the particular act itself, as opposed to the character of the individual engaging in the act. A state of blah-de-blah-de-blah, right? That's another, you can chase this down. So just skip over. Accordingly, professional services are those which require specialized skills, training, or experience. Okay? Plaintiffs contend the allegations against FIG arising out of, and they're saying, first off, arising out of is ambiguous. So that means it's going to count against the plaintiff now. This is the insurance company. FIGS works as an engineer and is exercising a professional judgment on the FIU bridge project in support of plaintiffs' emphasis the 11th Circuit analysis. Oh, great. FIG, for its part, insists certain allegations and the underlying complaints fall outside the exclusion. So FIG's argument also, and this is the court going against them too, but here's FIG, and the courts are using FIG's statement as part of their statement to this court document we're looking at, part of their analysis, if you will, the courts. And not if you will, it's called the title analysis from the court. And I'm reading it off to you and giving you my version of what you're looking at. FIG, for its part, insists certain, and listen to that, for its part, added this extra narrative. What the F do you have to add this extra narrative for? This is the court showing the direction. They're biased. They could have just FIG insists certain allegations in the underlying complaint fall outside their exclusion. So you guys know that I love psychology, and now we're looking into the mind of the judge and also the clerk or clerks who have participated in this document, because they added this wording here, for its part. This is psychologically, they did it because it shows where they lean to support. Remember, everything's data. You add it, and it makes conclusive file. If it makes a conclusive file, then you protect it. This is their conclusive file that they just exposed, their bias. All right, because this could have been left out. FIG insists certain allegations and underlying complaints fall outside the exclusion. FIG relies primarily on reasoning by non-Florida courts applying different frameworks to distinguish exclusions. Okay, I mentioned that up here that they reached into Pennsylvania here, right? Florida is the best way they should do it, not reaching into Pennsylvania. Goldberg versus National Union Fire Insurance Company of Pittsburgh, PA. Oh no, it took place in apparently it might have taken place in Florida, so they didn't reach out. FIG reached out of the state, which is nice, but it's sort of precedence, but it's not really state precedence. And so you can counter it. Okay. When you do that, then you can go into, you can then argue the other state precedents against this precedence. But if you keep it in Florida, you'd be arguing inside Florida Supreme Court precedents, that what they went for above, using the arising out of argument, that it's ambiguous. Okay. In support, plaintiffs emphasize the 11th Circuit analysis and Wickens Design Group Incorporated. Okay. Oh, I just said reabsorb that. FIG, for its part, in go back to that again, right? Most notably, FIG relies on an extremely instructive, as, quote, extremely instructive in the allegations in that actions against the insured/engineer were almost identical to those against FIG, and the factual circumstances giving rise to the action are likewise similar. Oh, I love this. This is a good argument. And where would it become? Where C general ID most notably FIG relies on. Let's click that for just a second. Okay, 2006, legaleagle.com. They usually give you some good data here. Let's see the 2006, Kenneth Potter, Philadelphia, PA, argued the cause of appellant Weber Gallo Simpson. Oh shoot! This is the one I was going to do a video for you guys. This is awesome. This is right down the road where I was working when this took place. The Pier 34 collapse, right in the Delaware, killed people. This is a very interesting story that they picked, and I thought it tied in when I saw it, and I said, that's why I said, oh, let me pull this up, because I remember this Hudson Engineers thing that they were down there at the damn river, and I was like, is this? And sure enough, that's why you saw me. I said I wasn't going to pull up case laws, but this one triggered me as reminding me of this Pier 34 incident. And it collapsed into the river, causing 3 deaths and numerous injuries to patrons. I remember it was like the wintertime. It was cold as hell. And they had notification of the decking of the pier. I believe the owner went to jail also of the pier. I didn't know the insurance company was arguing not to insure it. I think they would have a fair argument though, because they knew ahead of time. The divers went down there, checked out. They had a report that the pier would need structural repairs, so they had an insurable. If they were notified, then they should have spoken up. But if they weren't notified, then the owner was obligated to make the repair structurally sound. The owner did not. They did not make the repair structurally sound. But they didn't notify the insurance company, I don't think, about, hey, we got a messed up dock here. I don't think they did that. And I think that's what the argument for the insurance company is that we were never notified of the hazard. We had an insurable interest and nobody told us jack. And it was, I believe it was some days that went by. It might have even been weeks that went by before it was overloaded. Well, not overloaded, it collapsed because it was structurally unsound. Material issues, okay. Well, this is kind of important. Let me tie this. Let's see how this works. Right. Pier 34 was originally built as an earth-filled timber crib structure, approximately 225 feet long by 70 feet wide. The pier was widened and extended to 550 feet long by 100 feet wide in 1909. Okay, they're really going back. Let's bring this up. Hudson Engineers issued a report on January 17, 1995, recommending that a comprehensive condition survey be conducted in order to fully detail the exact nature of the required repairs. Ha ha ha. So the insurance company knew about that they needed to check this out, and then they tried to back out. So the insurance company couldn't get out of that one, can they? On May 24th, 1995, Pier 34 restaurant entered into a contract with J.E. Brennan Company, contracting engineers, Brenneman, a construction company, to stabilize and repair the inshore upriver collapsed section of the pier. Brenneman President Robert, also an officer of Hudson Engineers, contractually arranged to have Hudson Engineers design and engineer for the project. August 1995. While the repair work with the upriver section of the pier was ongoing, Pier 34 restaurant identified a crack in the seawall at the downriver outshore end of the pier. As a result, an employee of the restaurant met with Robert Hudson, vice president. Brennan retained Waterfront Constructors, a division of Brennan, to conduct an underwater diving inspection. Here's the diving inspection. The inspection verified that there were cracks in the seawall, defects in the pier. This is what I remember. And I think they collapsed is all I can remember next, because they were hush-hush because people were going to jail. I mean, they locked up people. Philadelphia lets you not do permits. I mean, you're supposed to do permits, but they let you do so many illegal things without permits. But when somebody dies, Philadelphia will lock your ass up. They're not like Florida. They will arrest your ass and prosecute. And they don't even have all the facts yet, and they lock your ass up first. They're not like Florida. They're not like we don't know what to do. They're like, we're just putting you under charges right now, so you won't be going anywhere while we gather the rest of our evidence and prosecute your ass. Philadelphia is pretty strong on that. Hudson Engineers advised the pier was moving away from the Pennsylvania shore towards New Jersey. Hudson Engineers discussed the methods to stabilize the pier with representatives. Oh, I remember they didn't do the work. There was like some shabby work going on, and that was about the extent of it. The method was rejected, however, The method was rejected, however, as not particular because it was too costly and would disrupt operations in the pier. This is what I remember. I was dialed in on this pier back then, the whole entire riverfront. 1995, I was dialed in from the Moochiloo, all that area down there, knowing what was going on for some years forward, but not there. Hudson Engineers devised an alternate method using A-frame braces